Professor, thank you for being here.
Thank you for inviting me. Very kind of you.
Yes, sir. Professor Imasogie is the chair of the University of Pennsylvania Carey Law School Board of Advisors. He co-founded PIPV Capital, a private equity and venture capital fund specializing in life sciences. He's an investor, an entrepreneur, and a lecturer in intellectual property law. Professor, you're a philanthropist, and your efforts include the creation of the Imasogie Professorship in Law and Technology and the Imasogie Gateway at the entry of the law school. I know that's just the tip of the iceberg of what you've accomplished in your life and your career. I want to thank you for being here again, and I'll pass it on to you to further introduce yourself.
I don't think I need to add anything to what you've done. Look, I think Penn Carey Law School is an amazing institution. I graduated from the LLM program in 1985, so just yesterday. And I've been really pleased to be affiliated and involved with the law school for quite a while.
So your course, right, called IP and National Economic Value Creation. I was a student in 2019, and on the first day of class, you told us that, quote, IP is the new global currency with a unique history. So I want to start by asking, how do you define intellectual property today, and what informs that definition?
Well, the first things first that we need to appreciate, particularly those who have a legal background, is that intellectual property is something we just made up. There's no natural law logic tree that gets you to IP. There is a natural law logic tree that gets you to physical assets, you know, to your house, to your pen, to your clothes. But in terms of intellectual property, there's no natural law pathway that says a check mark, which Nike calls the swoosh mark, should have any protection, or that a song or a piece of poetry should have any protection. So intellectual property is a total creation of the law. We kind of made it up from whole cloth. And in reality, what it is any form of creation that comes out of the human mind. Mm-hmm. We have different ways in which we protect it from a legal perspective. So, but the source of it all is the human mind. So to use the metaphor that I mentioned in class about it being the new global currency, the mint from which this currency is created is the human mind. Mm-hmm. Now, you can manifest it in different ways. You know, if it's more of a technical nature, more likely than not, you will go through a patent process. If it's more of an artistic nature, then you have a number of ways to protect it. It could be trademark, which kind of signifies the source and the quality of a particular product. It could be copyright, which is a thought that is fixed in a tangible form, and that could be poetry, music, the fine arts. It could be confidential information. So one of the greatest examples is Coca-Cola, the formula for Coca-Cola, where if you can keep it as a trade secret, then you have protection over it, and it creates billions and billions of dollars of value. And as I said earlier on, it could be confidential information, which is just keep it confidential, we have a contract in place. That and trade secret are somewhat close to each other. But the important issue is that there are a number of relatively well-established legal constructs that we can use to protect it. But the source of it all is what comes out of your mind.
Yes.
So that's what intellectual property is.
Yes.
And there are those who argue that it's a bit of a misnomer to call it property, but it has all the attributes of property. There's an ability to own it. There's ability to file legal suit about it. There's an ability to buy and sell it. There's an ability to split it up. So it has all the elements of property, and there's an ability for you to pass it on to the next generation. So, look at the duration of copyright, which is the life of the author plus, 90 years. That's a multi-generational asset of value. Yes. Every Presley's estate is still generating 30 to 36 million bucks a year. He's made more money since he died than when he was alive. The week Michael Jackson died, he made $100 million. So it has all the attributes of property without it being physical.
Mm-hmm. You mentioned in class, and this just shows how impactful your class was, because I remember these quotes. You said that it's a shared myth, right? And you spoke about Article 1, Section 8, Clause 8 of the United States Constitution, where the founding fathers of this country had the foresight to establish a clause that would allow Congress to be able to make laws that would promote innovation, but there needed to be incentives. So even back then, right, that clause allowed us to have things like this, right, and inventions like this. And so I remember that clause being something that really was sort of the funnel into the rest of the class for us.
Correct. I mean, the shared myth issue, when I refer to it as the new global currency, currency itself is an illusion. Right. Has been for quite a while. It has been for a couple of centuries now. You may have in your pocket a piece of paper called a US dollar. That's all it is, really. It's a piece of paper. There's nothing backing it other than the shared myth that we believe it's valuable, and the full faith and credit of the United States government.
Right.
Which itself is a shared myth. All currency, currently, it's a shared myth. People spend a lot of time talking about crypto and this, and there's a lot of discussion as if this is something that is remarkable and something that is new. Actually, it's not. The vast majority of the currency that we use in the US is electronic. It's digits, zero ones on a server somewhere. Mm-hmm. It's a ledger that has debit and credit on it. Physical cash in the US is very limited.
Yes.
It's a very small percentage of the value of the cash in circulation. Yes. So the vast majority of our cash is already electronic, and the only reason it has value, zeros and ones, is because we have a shared myth that it has value. Yeah. So in that context, intellectual property is nothing more than a shared myth, but a very profitable and a very, very valuable one. Over 40% of the GDP of the US right now is derived from knowledge-intense industries, which is remarkable. Yeah. It's the largest single driver of economic growth for us.
Yes.
The largest single driver of employment.
Yes.
And most people who are employed in the knowledge-intense industry tend to be paid more than people who are employed in non-knowledge-intense industries.
Yes.
So it's just a remarkable phenomenon that we haven't taken full advantage of. 1787, Philadelphia. America had just fought a war against, at that time, the sole superpower in the world, Great Britain. America had just won that war. And there were those sitting around the table on a steamy July in Philadelphia trying to figure out what the heck they're going to do with this quote-unquote freedom that they had, which eventually led to the idea of putting together a constitution. The fact that in 1787, there were provisions in the Constitution, and I'm so pleased that you still remember Article 1(8), that said Congress can pass laws to the protection of the useful arts, is really remarkable. It's like opening King Tut's tomb and seeing a cell phone in his hand. That's how remarkable it is. Something that happened in 1787 is now the bedrock of the U.S. economy in 2021. That foresight was crucial. And if you think about all the other issues they were dealing with at that time, the question of enslavement was a big problem. The question of 13 independent colonies, how do you pull that together into a nation? The debates about the rights of states and the rights of the federal government, the whole issue of who should be a citizen. I mean, these were very hefty issues they were dealing with. In the midst of that, to be thinking about intellectual property, the only way that makes sense is that if you look at the people around the table. One of the oldest individuals at the table was Benjamin Franklin, the founder of our great university. He was known to be an inventor, to understand the value of intellectual property, to have a printing press that understands a form of intellectual property, which is copyright, and so on and so forth. And you had other people, you had Jefferson, who was influencing what was going on, who became the first head of the patent office, the federal patent office in the US. So these were individuals who understood the value of the product of your mind.
Yes.
And it made sense to them that Congress should be able to pass laws to protect that. And they understood also, fundamentally, the economic ramifications of that. That if you can protect what comes out of your mind through the law, you could make money from it. And so that's the bedrock of what has happened in the US. And that's the bedrock of our intellectual property approach.
Yes. You've had a lot of different titles throughout your career, a lot of different positions. You're a business executive, an entrepreneur, an investor, a lecturer, private equity, venture capital, philanthropist, right? Famously, you had a newspaper route with your brother as one of your first jobs.
My first job.
And so throughout your different positions that you've held within those different industries, how has intellectual property been a common thread through your career?
Yeah. You know, IP has been, frankly speaking, the thread through which I've been able to knit together my career. It's been the grand norm, the basic element for each of my careers. And I think I've gone through 6 or 7 careers already. And in every single one of them, intellectual property has been of value. On the business side, as I mentioned earlier on, it is the most valuable asset in most companies. Because I spent a good chunk of my business career in the world of the pharmaceutical industry and biotech industry, in those industries, it is 100% of our value. Mm. If we come up with a formulation for a new drug, the only way we can protect it is through intellectual property. In terms of patents on the formulation, patents on the composition of matter, of the actual molecule itself. When we seek to market that product, the only way we can protect it is through intellectual property in terms of the trademark that we ascribe to the product. And of course, the only way we can protect all the materials we have around it, all the marketing materials, or all the written materials, is through copyright. So you can see that on the business side, where I've spent a lot of my time in biotech and pharma, intellectual property is central.
Yes.
Most big pharma companies, the legal department's intellectual property budget is how much do you need? Because that is what protects our assets. And the duration of that protection is what generates a huge amount of revenue. So on average, patents last for 20 years. So you have 20 years to generate the revenue to cover the risk of the investment you made in creating new drugs. If I look at the things I did when I was a partner in Pricewaterhouse, we're consultants. The value of our advice and our reports and our research is all protected by intellectual property. Yes. And we hold a fair amount of confidential information for our clients. If I think about my time practicing law, it's all about confidential information. You have attorney-client relationships, and you have documents that you create. Again, intellectual property is driving that value proposition. So, you know, from my perspective, every aspect of what I've done have had a good component of intellectual property. Of course, there's finance, there's consulting, there's advice, there's, you know, but at the end of the day, all that crystallizes into something that is protectable, and what is protectable by law, at the end of the day, is the intellectual property you create from that.
Yes. You didn't mention the paper route. How did
that was interesting. My first job with my brother. I guess I can always say that what we were delivering is a product of intellectual property.
Yeah.
I mean, people were delivering paper,
yeah.
and we had to go and collect our little fees for doing that.
Right.
If we didn't have the paper, which was intellectual property, we wouldn't have gotten paid.
Yes.
So even then, even though I was unaware of it, intellectual property was driving the things I was doing.
Yes, absolutely. Absolutely. So outside of work and family, your personal life, right? What do you enjoy doing? Any hobbies? And how has intellectual property sort of informed those hobbies, or how does it intersect with those personal hobbies?
The thing that I enjoy the absolute most in the world is to read. I've always been a passionate reader. Funny enough, my elementary school in Louisville, Kentucky, we had two libraries. We had a smaller library and a larger library. And in those days, you have to have, there was this, again, I'm dating myself. There were, in elementary school, you had all this Bookworm of the Year awards, and you got stars for how many books you read and different colors. And I was consistently the Bookworm of the Year. Okay. And I had the reputation, I read every single book in the small library, including the microfiche, which was incredible. So yes, that's my greatest love. It's reading. But over time, even though I have a pretty broad interest in reading, the genre that I've enjoyed the most, probably in the last 30 years, has been hard sci-fi.
Okay.
And the reason is that it is probably one of the most mind-expanding genre. Right. Where, you know, the difference between, let me clarify something, the difference between regular sci-fi and hard sci-fi is that hard sci-fi are written by scientists in their areas of expertise. So this is not fantasy. So think more Star Trek, less Star Wars, right? So if you have a PhD in astrophysics, you write a book about astrophysics that includes astrophysics. And if you have a PhD in biology, or if you're a physician, you write books that, you know. So the science in the stories have to be rigorous. You are allowed to extrapolate a little bit, but even your extrapolation has to have a scientific basis to it. So it's really fascinating. It's a subgenre, and I really enjoy that. And of course, core to all of those stories is intellectual property. Yes. And what I enjoy the most is that they have a commentary on how technology, how intellectual property affects the social environment. Yes. And the ethical and moral environments. Hard sci-fi is so fascinating because in almost every book written in that genre, ultimately you bump across or bump against or you bump through the question of spirituality and the question of what are the ethical and moral issues that we should wrestle with around intellectual property. So it's funny, but intellectual property has really driven me into to develop a taste for hard sci-fi, and I really enjoy reading it.
Yes. Star Trek is my mother's favorite series. So I remember growing up, she would always have it on very late at night. And to your point, it's been interesting to see them continue to evolve through the translation and updating of their copyrights, right? And you also mentioned just your passion for hard science. I remember you referencing the book by Michael Crichton. Am I saying it correctly?
Yes.
The title of the book was
Next.
Next, right? Focusing on patents, right, and sort of this sci-fi perspective of where that could go. I haven't read the novel yet, but can you speak a little bit about that?
Well, I brought up Next in our class for a very simple reason. There's a case that we had discussed, which is the Moore versus UCLA, Regents of UCLA case, which was a fascinating case out of California. The case ended up going all the way to the California Supreme Court. And in essence, it was whether or not a patient who was Mr. Moore, who had been a construction worker in Seattle, who unfortunately was diagnosed with having hairy cell leukemia, which is a form of cancer, a form of blood cancer. And he had been referred to a professor at UCLA, interestingly with the name of Dr. Gold, and who was an expert in hairy cell leukemia. So he was referred from Seattle to LA for treatment. And in treating him, Dr. Gold quickly discovered that Mr. Moore had a mutation in his cells that could be manipulated to make this cell line immortal. Okay. Now, there's a whole bunch of value propositions if you can get an immortal cell line. And Dr. Gold, realizing this, sets up a private company, files a series of patents in the name of UCLA, because he was a professor at UCLA, around the immortal cell lines of Mr. Moore. And once those patents issued, he licensed those patents from UCLA into his private company. And Dr. Gold goes off and makes a boatload of money from exploiting the cell line of Mr. Moore. Mr. Moore does not discover that Dr. Gold is doing this to him for 6 or 7 years. So for 6 or 7 years, he's coming from Seattle to LA to be treated by someone that he trusted, he considered his doctor. And Dr. Gold literally mined Mr. Moore. He took blood from him and ultimately took out his spleen. He just kept on mining this guy to get more cells for his business. Ultimately, Mr. Moore discovers and brings suit against Dr. Gold. So that was a very interesting case, and a whole bunch of legal arguments. But at the end of the day, the California Supreme Court, which most people would consider a pretty liberal state within the American context, found that Mr. Moore had no interest, no rights to his own cell lines.
Right, I remember that.
And that Dr. Gold had patents that he had been able to obtain, and those patents were upheld. And that the only thing that Dr. Gold may have done wrong was not going back to Mr. Moore and giving him additional information about the business he was doing on his cell line, and therefore maybe there wasn't full consent given by Mr. Moore to Dr. Gold. Now, a very peculiar, in my view, a very peculiar case, but it's a case that has withstood time. Michael Crichton saw that case, and his book, Next, was predicated on that case. But he took it a bit further, and in his case, the character of Mr. Moore, Dr. Gold's business rival, destroys his character's cell line, the cell line that Dr. Gold had taken from Mr. Moore. And Dr. Gold, again, this is in the fiction, in the book, the Dr. Gold character then goes to court and gets a court order that he can go back and mine Mr. Moore, the Mr. Moore character, for more cells, because he owned it, because he had patents on it. So the Mr. Moore character is running all over the world trying to hide from the Dr. Gold character. It's fascinating. But that is a situation where, life was probably stranger than fiction.
Yes, more for more.
More for more. Mining Mr. More. And of course, there's a host of ethical and almost spiritual issues that arise there. But the Supreme Court of California said, the patents are fine.
Transitioning. Family life. This question is interesting to me because when you think about family and legacy and traditions and future generations, there's a lot of ways in which intellectual property intersects with those areas. I was born and raised in Florissant, Missouri. My father's from Abia State, Nigeria. My mother's from the Pruitt-Igoe projects in St. Louis. They're still alive. I'm grateful. But their legacy is already set because of their faith, how they treat other people, and their sacrifice that allowed, I'm the youngest of 7. My parents' sacrifice enabled us, right, to have access to what is deemed as quality education, which allowed me to come to Penn Law. And when you come to Penn Law in Philadelphia and you walk up the stairs, there's a name visibly etched in the law school. It's your name. So how has intellectual property influenced your family and your legacy?
So a couple of things. I'm fortunate, my wife and I are fortunate to have 2 kids. They grew up in a world and in a family and at a dining table and at sports events and vacations and family gatherings where intellectual property was discussed ad nauseum. So I feel sorry for my kids. They almost had no choice. They heard dialogue, debates, philosophical views, spiritual views about intellectual property all their lives. And I think the impact of that is that they understand its value proposition. Both of them are running their own businesses, and both of them are in the world of creatives, and both of them have done a great job making sure that they protect intellectual property that they create in terms of their contents and their clients and everything else. So it's a central part of their lives and a central part of their businesses. And I'm thrilled to see that. Once in a while, they consult with the old man around intellectual property issues, but they're sufficiently sensitized to be able to identify the intellectual property issues and to understand the value proposition that it holds. And it's to them in good stead in their businesses. They make money because they understand that. So that's part of the legacy. Part of the legacy is, once you've dealt with Maslow's hierarchy of needs, the rest is a question of flexibility that helps you narrow the gap between thought and action. And so what would have been additional assets for my children, I'm very comfortable donating to the law school. And one of the areas that I'm most thrilled about is what you mentioned earlier on, the Imasogie Professor of Law and Technology. I'm particularly thrilled that Chris Yu is the inaugural holder of that seat, of that chair. I mean, he's just brilliant. I mean, he's just brilliant, and his brilliance covers both the technical aspects of intellectual property, the business aspects of intellectual property, the strategic aspects of intellectual property, the legislative aspects of intellectual property, the legal aspects and the ethical aspects. And we could not be more thrilled, Osagie and I could not have been more thrilled that Chris was the first person to occupy that chair. But it's a resource allocation question, and we are very comfortable allocating resources to back that, as opposed to using it for other things. So I joke all the time for my kids. I said, "Thank you for allowing me to use some of your your inheritance for things that I'm very excited about," which happen to be intellectual property oriented.
Yeah. Thank you for sharing that. I want to echo and underscore, Professor Yu. I had him as a professor as well in his internet law and privacy class, and really enjoyed that. So maybe I'll have a conversation with him in the future. So the final question, the intellectual property system. The challenge of all categories of IP is how to adapt them to new technology. You've mentioned often that there's significant economic benefits from IP, but there's also significant moral and ethical questions. You've also said, I think you mentioned this in class, whatever is sufficient to get us to this point is inefficient to get us further. So barring all aspects of what you know about intellectual property and looking into the future, what is one thing that you would change about the intellectual property system in the United States? And what would be the effects of that change?
Okay. Wow, that's a big question with significant ramifications. All right? But let me try to address it, at least give 2 or 3 thoughts. We could have a month of discussing that question. But let me give you at least 2 or 3 thoughts. So that quote that you just referred to that I use all the time actually came from a fortune cookie.
Were you eating the meal and
found
found
it? Chinese
Okay.
meal.
Okay.
And I thought it was a wonderful quote.
It
that
is.
what has been sufficient to get us here is insufficient to get us further. Okay. 1787 was where we started the journey in the U.S. When it comes to intellectual property. We're now in 2021, and since 2024. Yeah. That's a long period of time. What we are doing is that we're using 17th, 18th, 19th, 20th century concepts, legal concepts, to manage 21st century technology. That's challenging.
Right.
I think we need to pause and give some thought to that. All right? Generally speaking, I'm still a strong supporter and proponent of intellectual property protection, but I think we need to think about the constructs that we use to give that protection. Second thing, I think we need to really give some thought to the duration of intellectual property protection. With regards to patents, because of TRIPS and all that, we have a global view on that now. So it's, okay, we've kind of standardized it to 20 years. But if you recall, Germany, for example, had different durations for different types of patents.
Okay.
So some had 5-year patent protection, some had 7 years patent protection, some had 21 years patent protection. But we've standardized it now to 20 years. And there's a question in my mind whether 20 years is the right duration. In the US, we've even gone much further when it comes to copyright. The joke about how the length of copyright protection increased. It was Walt Disney wanting to extend the protection that he had on Mickey Mouse. And he was able to influence people in Congress. I guess we call it lobbying, but it involves some money and them doing things that you want them to do, and the end result is that we got a significant extension of the life of copyright. Does that make sense? Is there an economic model that says the life of an author plus 90 years is the right duration of copyright protection? Especially when the average lifespan has gone up. So if your average lifespan for the most successful zip codes in America, the average lifespan is as high as 80-something years. So 80-something years plus, you're going to have a 160, 170-year protection for a piece of copyright? Let's run the numbers. Does that make sense? So I think we need to have a discussion about the duration of intellectual property protections we have. And then I think we need to have, there's a thought comment I'll make, because as I said, we could talk about this ad nauseum. I think we need to have a serious conversation about what is protectable.
Okay. Right.
If you remember, one of the first questions I asked you, the first class, is that I asked, can you tell me something that cannot be bought and sold?
Right.
And it's always a question I ask, and I always enjoy it because, some of the brightest students in the country wrestle with that question. And there's a knee-jerk reaction, and people say things like air, right. And I start laughing. I say, right. Have you ever heard of air rights? People talk about water, and then I give you multiple examples where rivers are bought, lakes are bought and sold by companies and governments. So I think we need to have a philosophical discussion as to what is patentable, what is protectable in the different forms of intellectual property we have. And I think that's going to become even more crucial as we move and progress with the technology of AI, because it's going to push us to a question as to what does it really mean to be human, and where are the limits of what we can own. I see the ghost of the 14th Amendment rising up again as to what we can own and what is human. So I think there are deep philosophical issues that we need to debate. And my concern is that there is such an amazing amount of economic value in the world of IP that it blinds everyone to the harder questions of morality and ethics and things of that, and social impact. So it's going to be difficult to engage in those discussions, but I think the academy is the place for those discussions to start, and then hopefully we'll get it sensitized to those who are in positions of authority.
Professor Imasogie, thank you.